one of the things that I wanted to discuss, you had a good video on this as well, and we've talked about it a little bit at the Reload too. These sorts of laws that are being challenged in this case, right? The AR-15 bans. One of the issues that a lot of people will discuss with the court system and challenging these particular kinds of laws is in how I think a lot of people view the Supreme Court as perhaps being favorable to striking down an AR-15 ban based off of the common use standard laid out in Heller, like you alluded to earlier. But the issue seems to be in getting a case there. And a lot of people are skeptical that you could actually get one up there. And I guess this kind of also goes to the fairness of the process argument that you just spoke to, because these laws are only passed in more liberal states, right? You're not going to have Texas pass a law like an AR-15 ban. And so the Fifth Circuit Court of Appeals is never going to handle a case like this. It's always going to be the Ninth Circuit, the Fourth Circuit, the Second Circuit, the First Circuit. And, they tend to be more liberal courts because the judges are drawn from those states and how the system works. And the Supreme Court primarily functions to settle circuit disputes. So they're going to take cases much more often, at least, where there's a disagreement between those lower court circuits on whether or not a law is constitutional. And the issue then is, well, if the Ninth Circuit and the Fourth Circuit uphold assault weapons bans, there's no disagreement, and so it's harder for the court to step in. What's your view of that whole situation? Do you think that makes it unlikely for the court to take up this case, even if, whatever the Fourth Circuit ends up actually doing with it when they do hand out a ruling?
Well, right. There's really three general ways the Supreme Court will grant cert, or what they look for before they agree to hear a case, which for all intents and purposes, they have complete discretion with very few examples that are otherwise. So they have complete discretion as to what cases they take under their cert authority. They usually look at one of three things. The first is, and this is the most common, is there is a circuit split, meaning that the First Circuit Court of Appeals in Boston says that a law means X, and then the Ninth Circuit Court of Appeals in California says the law means not X. So now you have two different parts of the country operating under the same law, but it's being interpreted 180 degrees differently. And because of that, for uniformity and to make sure that Americans are all functioning under the same uniform national laws, the Supreme Court will often take that kind of a case to resolve circuit splits. Sometimes it's called reserving a split or fixing a split of authority. That is very common. And you raise a good question, which is what happens where AR bans and semi-automatic rifle bans all arise in the same handful of nutty anti-gun states. They are being litigated in front of, the judges that have mostly been appointed and are blessed by the nutty anti-gun politicians in those same states. How does that play out? Because you're never going to have a Fifth Circuit Court of Appeals decision down in Texas knocking out an AR-15 ban, because there's never going to be an AR-15 ban enacted in Texas or Louisiana for them to rule on. So yes, when it comes to a circuit split, I think right now it's unlikely, and this is good news for the Second Amendment community. There is unlikely to be a circuit split because the vast majority of America is still favorable to the Constitution and the Second Amendment. That's why we see this explosion in permitless carry regimes and people recognizing that you are your own first responder. And yesterday's decision or report by the Department of Justice about how terrible those 400 police officers in the Uvalde situation, how they really did not get the job done for a whole host of reasons, according to that report, only reminds people that at the end of the day, we are our own first responders, and we can't trust 911 or the police necessarily to protect our lives. So I think the gun rights movement continues to be strong, except in these certain states that are bad on guns, that are basically controlled entirely by the Democratic Party. So the question is, how does the U.S. Supreme Court hear a case dealing with a semi-automatic ban where you're never going to have a circuit split? Well, that gives rise to the two other ways that the court will often consider a case. One is it has some sort of national significance. Bush versus Gore in 2000 would be an example of this. There's no circuit split of how you count falling Chads in Florida or anything like that. But it was obviously an important political decision for national significance as to who was the president in 2000, down in 2000 with Florida. And then, of course, you have things that set what are known as set important precedential values. And I think that's where this would fall. The good news is, as I talked about in my video, Stephen, is there's at least 2 Second Amendment cases of the 4 modern cases. The 4 modern Second Amendment cases, as you know, is the 2008 decision in Heller, the 2010 decision in McDonald, the 2016 decision in Caetano versus Massachusetts, and of course the 2022 decision in NYSERPA versus Bruin. But if you look at those 4, of the 4, 2 of them, there was no circuit split. There was no circuit split about, whether or not stun guns are protected arms under the Second Amendment, which is what the Caetano case presented. And yet the Supreme Court took that case and reversed the Massachusetts ruling and effectively said that stun guns are protected arms. And that was essentially the holding, and sent it back, and Ms. Caetano got off on that grounds. Then, of course, you look at the 2010 decision of McDonald versus Chicago, another example where that was no circuit split, and yet they took the case. So half of the modern cases involving the Second Amendment arose in the context of no circuit split. So that should give people optimistic reasons for why the Supreme Court will take Second Amendment cases, even if there's no circuit split, especially that's something so significant as an AR-15 ban, because it's simply outrageous that in the vast majority of America, you can have any of these firearms and readily, and no big deal. And then in these handful of states, these malum prohibitum crimes, which means no evil intent. There's nothing inherently evil about any of this, what you have in the back of your closet. And now you get to go to prison for 10 years. This is the sort of thing of this disconnect in America that I think the Supreme Court will ultimately take when they get a case on the final judgment. The other thing to keep in mind is if you look at this term, meaning this current term, Stephen, this started in October of 2023 and which will end in June of 2024, you will see there's a series of cases that have been taken with no circuit split. I think the most interesting one is the January 6th case, where the Department of Justice has not only gone after these January 6th protesters / trespassers, whatever you want to call them, and try to convert a lot of these into felonies by using a statute that deals with witness tampering and document destruction that arose out of the Enron financial crisis. And this has been novelly applied by the Department of Justice, not just to the January 6th protesters, but also half of the indictments, meaning half of the counts of the indictments against President Trump himself, have been based on this law that, as up until now, has always been understood to be simply you can't destroy documents if you're under subpoena, you can't tamper with witnesses and threaten them before a court case, things like this, basic common sense stuff. And somehow Jack Smith, the special prosecutor, as well as the Department of Justice, have tried to take this law and apply it to all these protesters and President Trump involving January 6th. But the Supreme Court, despite the fact there's no circuit split on the question, has just granted cert in that case. And that's another kind of example where the court will take cases where there's no circuit split if it's particularly important. And I think an AR-15 ban case is going to be viewed as very important. And I do think there's really certainly 5 and likely 6 votes in our favor. I think Roberts might be an issue with granting cert, but once the case is up there, I don't think there'll be any problem whatsoever in getting a 6-3 decision. The semi-automatic rifles are protected arms under the Second Amendment, no different than semi-automatic pistols are protected arms under the Second Amendment in Caetano and, of course, in Heller.